Hi, I'm Rick Peltz-Steele at the University of Massachusetts Law School, and I'm going to talk to you today about climate litigation as part of our global environmental legal system. So I'm going to refer you to the climate change litigation databases. You can find resources here at climatelaw.org, and you can, from there, go to the climate case chart, or you can link directly to climatecasechart.com. You'll find the climate change litigation databases, which are a U.S. database or global database maintained by Columbia Law School. These databases are studied annually by researchers Setzer and Higham at London School of Economics. And here's a map they produced on 2023 data, so a little social science lag. They did their research in 2024 on the prior year, showing the distribution of cases in the database. There are almost 2,700 cases, and they are in 55 plus countries. Most of these cases arise in the United States, 1745, with the largest number of new filings there as well. That's a little bit because there's really good reporting in the United States, but it's also because there is more litigation there. The United States tends to be a weak regulatory system and a strong litigation system. Other leaders in the world behind the United States are the UK, Australia, both common law systems, multi-jurisdictional cases in the Court of Justice of the EU, and then Brazil 82, Germany 60, as you see here. There are more than 200 cases in the databases from the Global South. As you might suspect, that low representation overall in the Global South is partly due to a low number of cases owing to development of environmental legal systems. It is also, of course, due to a lower reporting percentage. We do see growth in reporting in the global legal system. Over time, there's a great increase in cases across the world, both in the United States and globally, in the red and blue bars. There was a bit of a spike around the pandemic that was owing in partly to NGOs, civil society organizations, turning resources to remote activities such as litigation. But it was also the time when President Trump pulled the United States out of the Paris Accords, which caused some other countries as well to rethink their obligations. So we see the number of cases leveling off a bit, but overall, in the long term, there's certainly a trend increase. In terms of the theories that are expressed in these cases, they are much as you'd expect. They're administrative law, a lot of that dating to compliance instruments based in the 1960s, 1970s development of environmental law. You see consumer protection theories, which could be about misrepresentation and greenwashing, about competition, about advertising. Tort-delic theories for compensation based in nuisance, negligence, product liability, and the largest growing category, which is human rights and constitutional law, both in international courts, such as those shown here. ECOWAS has been active in Africa. We see involvement in ICJ and the European Union. And increasingly, we see the involvement of domestic high courts on human rights bases and also regional human rights courts. Provision I pulled from my home state from 1972, same era of environmental law. I wanted to show you that there's language here, if I highlight it, that could be the basis of a right to a healthy environment or rights vis-a-vis climate change. This provision has not been used in that way. It's only been used to halt the development of projects that might compromise public parks, which is pretty narrow. But I point it out because especially subnational public entities across the world often have these dated provisions in their constituting instruments. And it sort of remains to litigation in the courts as to whether these instruments might be given new life in our present era, as they have been in some jurisdictions. So those are the legal theories. But another way of thinking about climate litigation is in terms of who are the petitioners and who are the respondents. And of course, you could break these down by subject matter, but I'm just going to talk generally about this. So petitioners, we see 70% of NGOs or civil societies or individuals, often both. We see a trend of increasing government petitioners. These are usually subnational governments, so state and municipal. We also see an increasing number of corporate and trade associations. Some of these are non-aligned cases, that is to say, not in the interest of environmental protection. I'll talk about that later. A large number, again, in the United States. In defendants and respondents, we see 70% government respondents, 25% corporate. This is a change from what was formerly a 50-50, close to 50-50 balance. But that change seems to be resulting from a divergence. There's a large increase in public respondents in the United States to 85%, a smaller increase in public respondents to 60% globally. What looks like is happening is that the 70% overall is being pushed by the United States, where it's just been easier to sue governmental entities than to sue private actors. So another way of looking at the cases is through the character of the respondent defendants. And here we see an interesting trend over time. In the green and white checkered part of these bands, you'll see that fossil fuels always has been a large actor on the defense side and continues to be in 2022, 2023. But one thing you see trending over time is a diversity of respondents here. So what's happening is plaintiffs are suing actors across a greater number of sectors on the private side. And this is causing a reaction in business, in insurance, and in legal counsel to be more sensitive to environmental risk exposures. So Setzer and Hickam actually break down cases, active cases, according to the strategies they represent. And this is a really useful way to think about environmental litigation. Probably the highest profile case is government framework cases. This is where somebody looks at the government and says, hey, you're not complying with your obligations under the Paris Accords. And so this is a large number of cases, a large increase. There are wins to date looking at about 1 in 3 for petitioners. Another large the largest category of cases are called integrated climate considerations. This is where public actors are in a licensing capacity, or the private actor is trying to get a license for a project. And we're looking at environmental compliance, such as with impact statements or human rights obligations. Setzer and Hickam say this category is so large they didn't want to put a number on it. It shows the largest increase in 23. Another category, polluter pays. This is more classic tort cases where someone complains of injury. Smaller category, but important category, mostly in the United States, probably because the litigation system is friendlier to tort claims than it is to compliance claims. But one thing to note about this category is that overall complainants have been unsuccessful so far. Corporate framework cases look to use the corporate accountability system, that is, such as a shareholder derivative suit, to get corporation to comply with its stated self-imposed obligations, a small but significant category showing a fair win rate for petitioners of 1/2. This is widely outside the United States, which might be the reason for the small number of active cases. And that's probably, I would speculate, because it's very hard to hold private actors accountable in the United States. Another category, failure to adapt cases. This says, hey, there's a sea level risk, rising sea level risk, whatever threat to the environment, and you, private or public actor, are not doing your job to change, such as fossil fuel dependence, to protect us. Transition risk is where we see a transition happening, such as change to renewable energies, but there's a lawsuit around that transition to say it's not being done right, or it's not being done fully or correctly. Growth is expected in this category as we see more transitions to renewable resources. Climate washing or greenwashing cases represent a very large number of cases and a large uptick in cases, also a large win rate at about 70%. But there is a caution here in that while these cases do show a good win rate for environmental complainants, it must be remembered that these cases only bring about transparency. They don't actually bring about a change in defendant or respondent behavior. And finally, a category of so-called turning off the taps. This is trying to intercept resources that would go to, for example, fossil fuel extraction by going after the ethics obligations or the legal obligations of an actor in the financial chain leading to extraction, for example, something with environmental impact. So we can talk about recent developments in case law in 2024, largely. Late 2023, we've got significant development in the United States, although at the state level, in a sparsely populated state, government framework case in which a constitutional provision at the state level was used by youth activists to successfully complain to the Montana Supreme Court about environmental laws that would have restricted requirements on environmental impact statements for fossil fuel projects or greenhouse gas emissions. And this was a provision very much like the Massachusetts provision that I showed you, in which the Montana court said, yeah, we're going to hold this provision to have contemporary meaning in climate change. Now, that's still a very isolated outcome in the United States, but it made waves. The next, the VKSS case versus Switzerland in the European Court of Human Rights. Here, the court recognized a case by elderly Swiss women who complained that their lives could be shortened, for example, by heat waves, for Swiss government failing to comply with its obligations to control climate change, another government framework case. And the European Court of Human Rights used Article 8 for protection of privacy rights and integrity of the family to ground a right to a clean environment. Significantly, the court did reject two other cases, including a youth climate change case out of Portugal, saying that there was a failure to demonstrate injury. The North Sea Fields case in Oslo District Court in Norway has been one to watch. It is in the integrating climate considerations category, where the complainants alleged government failure to require the requisite environmental impact statements on oil extractive activities in the North Sea. So that was a win in district court, which is significant. It bears remembering that the respondents can then go ahead and comply with the statements and might be able to proceed with their extractive projects. Smith v. Fonterra in New Zealand, a significant development in 2024, in which a Maori leader complained of indigenous interests in customary land rights, as well as fisheries rights. Corporate framework case in the tort delict category, where there's a seeking for compensation and injunction against mostly nuisance theories against greenhouse gas emitters. It's only a pretrial disposition, but significantly, the New Zealand Supreme Court allowed the plaintiff to proceed on remand. Rajitsan versus India is a green-on-green case in the Supreme Court of India. It was about Indian compliance with its Paris Agreement requirements. So India was trying to switch to electrical from fossil fuel dependence, but in doing so, stringing high voltage lines across the country. The complainants said you didn't do your environmental impact work and you're endangering a couple of bird species. So this is classified as a green-on-green case. The court kind of split the difference in its ruling, but significantly, like the European Court, used the right to life and liberty in the Indian Constitution to recognize a right to a healthy environment vis-a-vis climate change. Now, I mentioned that a lot of new filings in the databases in 2023, I mean a lot, 50 out of 230, overwhelmingly in the United States, are so-called non-aligned cases. So these are cases that are not exclusively in furtherance of environmental protection. Some of these are green on green, as in Richardson, but some of these cases also are corporate or trade association cases against environmental protection concerns. Some are strategic lawsuits against public participation, against an actor such as Greenpeace. And some are ESG compliance complaints. So kind of saying we're investors, shareholder derivative, and you went overboard in your environmental compliance. And we want to see more retrenchment in fossil fuels. By the time you hear me say these words, there might be advisory opinions out of the International Court of Justice and the Inter-American Court of Human Rights. States have asked for advisory opinions on state obligations for a healthy environment under international human rights instruments. So we'll see what those courts have to say. And that's what I have to share with you today. Thank you for listening.